Hi friends, welcome to my YouTube channel Shorthand Dictator. If you like this video, please don't forget to subscribe my channel and share with your friends. Let's ready. 1, 2, 3, start. This is an application to us under section 622 of the Civil Procedure Code, and the complaint is that the small cause court, acting under section 38, has committed an error in jurisdiction. Stop para. The facts of the case, as alleged by the plaintiff, are that he advanced a sum of money to the firm of Dictator and Dower, and as security for that advance took a promissory note. Stop. The promissory note is signed in the handwriting of one Dhanjisha Harmosji Dower, who at that time was undoubtedly a member of the firm of Dictator and Dower. Stop. The other member of the firm was the present defendant, Dictator Kaikhustu Dictator. Stop. Prior to the suit, Dhanjisha died, and so proceedings were taken against the surviving partner alone. Stop. Para. The record before us does not contain any summons, but a letter addressed to the defendant under section 91 of the Civil Procedure Code, in lieu of a summons. Stop. Para. That letter is based upon an affidavit made by the plaintiff on the 4th September 1904, and this affidavit, as far as we can learn from the record, that the statement made to us by the counsel and pleader appearing in the case, is the only document which contains the claim as formulated by the plaintiff himself. Stop. Para. We are told that according to the practice of the court, the letter, though based on that affidavit, was prepared not by the plaintiff, but by the court officer. Stop. Para. Now, the letter treats the claim of the plaintiff as based only on the promissory note. Stop. Para. The affidavit, however, is not thus limited, for, though it states that the defendant is indebted to the plaintiff in sum of rupees 400, being the balance of the amount for the promissory note of rupees 500, there is the allegation that the amount was borrowed for the purpose of the firm. Stop. Para. The case came, in the first instance, before the fifth judge of the small cause court, who passed a decree in plaintiff's favor. Stop. Para. The matter was then taken to the small cause court under section 38 of the Presidency Small Cause Courts Act, with the result that this decree was reserved and the suit dismissed. Stop. Para. The ground of this decision was that the suit was brought on a promissory note against a person by whom it was not made, and that such a suit was bad in law. Stop. Mr. Seher, for the plaintiff, has contended that the small cause court exercised a jurisdiction it did not possess in dealing with the matter in the way it did, and urged that under section 38 of the Presidency Small Cause Court Act, it could only exercise revisional jurisdiction. Stop. By that, it was meant that it would only act in revision within the limits within which this court acts under section 622 of the Code of Civil Procedure. Stop. Para. In my opinion, that contention cannot be supported. Stop. Section 38 of the Presidency Small Cause Court Act is a part of chapter 4th, and that chapter is headed New Trials and Appeals. Stop. Section 38 itself is in the widest possible terms, and I can find nothing in that section that supports the contention that the powers of the small cause court under section 38 are limited in the manner suggested. Stop. Para. It has next been urged that in taking the view it did of the signature on the promissory note, the court committed a gross error. Stop. para. But that would not enable us to interfere under section 622 stop. Then it was argued that the court, in holding that only the maker of a promissory note was liable, had failed to give effect to the provisions of the Contract Act, while which make a principal liable for the acts of his agent. Stop para. In the first place, I am not at present prepared to say that the small cause court did commit an error in holding as it did stop. But even if the court did err in this respect, still that would not entitle the plaintiff to claim relief from us under section 622 stop para. Thus far, therefore, the plaintiff has not made out for a case for interference stop para, but there is a ground on which, I think, we ought to set aside a decree of dismissal stop.